I'm sorry, I didn't mean to talk. I just assumed when I asked you to sign up that it'll be like, I'm not all signing on. It's on the laptop. Oh, sorry. Someone, kids getting it? I think it's on the top in front. Oh, to get into his name, I'm sorry. Eight two three 5898 2492. Doesn't matter, I'm about to start. 143 765. And to agree, it's being very slow. What happened? 823 5898 5898 2492.
Like, no. I assume that's why.
I make out.
Not.
Can I go right for me? I'm not writing,
What do you think? What was it?
but it's gonna work, that's why. Okay,
We are opening that up.
2 years.
By the time you get there.
Thanks, Annie.
Thank you. Gina, you can read out the heading.
Okay. Good afternoon. Monday, the first day of November 2021, Court Commercial Court 2 via Zoom at 2:36 p.m. before the Honorable Justice Tibet Williams. Appellate Jurisdiction 2020, number 26. The Queen versus Troy Woods. Ms. Shante Simons Fox for the Crown. Mr. Woods in person.
Thank you. Can I just note that we are expecting some interruption over the next few minutes because I have asked counsel who will be appearing for a mention on another matter, another criminal matter, and which is also open court, to join this Zoom appearance. I will deal with that mention as I see, once I see that everyone is present. I expect that it will only be a few minutes and then I will return to this matter. But I think it would be too time wasting for me to have two separate Zoom appearances.
Yes, ma'am.
So that's how I've decided to deal with it. All right, you are Mr. Woods?
Yes, ma'am.
So
Good
what's-
afternoon, lady.
Can you hear me clearly?
I hear you, ma'am.
All right, good. This is the Crown's appeal, so I expect that I will be hearing from Ms. Simons of Fox very momentarily. I would invite you, Mr. Woods, if you want to say anything, you can obviously take off your mute button, but it may be helpful for you to keep your mute button on while the prosecutor is addressing me.
Yes,
Do
lady.
you want to put your audio onto mute?
I guess you leave it at this.
All right, you can just, all right, we'll see if that's disrupted. Why don't you leave it like that? Yes, Ms. Simons Fox.
Yes, my lady. Do you have a copy of our submissions?
I do, and I have seen them. Thank you.
Thank you, my lady. This is an appeal. It's the Crown's appeal, my lady, against a sentence in the magistrate's court, the respondent having been convicted in relation to the information 19 CR 00350 on the 30th of September 2020 and sentenced on the 6th of October 2020. This is also an appeal against the decision in law which led the court to deal with the respondent in a particular way so as to permit his existing probation order to continue without sanction following this conviction. My lady, the respondent was convicted on this information on the 30th of September 2020 after a full trial, and in particular, found guilty of one count of obtaining property by deception.
Okay,
There-
sorry, let me just pause you there for a minute, please. Because I was a bit confused by the challenge to the existing probation order. That probation order was made in a separate criminal
Yes.
proceeding?
Yes, that probation order was made in a separate proceeding, and it started about 4 weeks before this crime was committed.
Right,
that-
why- the magistrates dealing with the probation order, wouldn't that be an appeal in those proceedings?
Yes, my lady, it could be an appeal in those proceedings.
I mean, how would I? The only file I have in front of me is appeal number 26 of 2020 and the facts that relate to this. So how would I be placed to properly assess whether or not the magistrate should have varied or done anything other than what he did in respect of a probation order made in separate proceedings?
My apologies, my lady. I thought that both matters, and I'm just referring to the notes from our former counsel, Ms. Tucker, that both matters were to be heard at the same time. I could be
I think-
wrong in my notes.
No, I think that was previously an intention, certainly of your office, because I was looking at my note from the 18th of February, 2021, that court of appearance, and I can see that I made a note of another CJIS number ending in 446.
Yes, that would be the one.
Right. So, and then I in fact directed for that record to be prepared, but it's not in front of me.
My apologies, my lady.
And it's kind of you. I'm not sure it really is something for your office to apologize for. It. Maybe that's an administrative oversight on the part of the court administration. I don't know, but I should tell you that here's the end result is the same. I don't have the matter in front of me.
Yes.
And so I think I would be really challenged to assess how a probation order should have been dealt with under these current circumstances. Now we can do two things. If it really is the case that they must be heard together, then we can come back another time and deal with it, or it will be dealt with in separate hearings.
My lady, either option is fine for the Crown. If you do want to hear them together, I can make sure that a record is prepared and filed with you this week so that we can continue this in full.
You have that power? I thought that was something the registrar would have to make done for.
I'm sorry, my lady, I mean filing the paperwork for the record,
Oh, I
the
see.
creation of the record, yes.
I see. Oh, has that not been done?
Well, I have in front of me all of the paperwork. It's just not in a blue cover, so I'm not sure if this has been done, but I can check. Maybe whilst you are mentioning that other matter, I can check with persons in my
Yeah, can you
office.
just check to see how onerous that would be, and then I'll just stand this matter down and deal with the other mention that I
Thank
have. All right, Mr. Woods, if you can just remain where you are. I'm gonna deal with another matter of just for a few minutes, and then we'll come back to your matter, okay? And I'll explain to you what all of that exchange was all about. I did not hear you, but I took from your body language that you said that's fine.
I'm sorry, I thought, yes, ma'am, I hear you.
Okay, all right. Okay, so can I ask, please, for you, Ms. Asma, to read, are you able to read out the matter for the Curly, Clark, and Adley matter, please?
I would have to come and get it. 1 minute.
Sorry?
I'll be right back. Come and get it.
Sorry, Ms. Oswald, it may be because I spoke with Ms. Dyer and I know that her and Ms. Robinson were intending to assist me with this.
Yes.
So not to catch you off guard, I'm sorry, I didn't want for you to, I don't think anybody could have expected you to be prepared to call this. But do you see them on the line? Do you see either Ms. Dyer or Ms. Robinson on the line?
No, I don't see.
I don't. All right, well, if you can grab the heading, then maybe I can, or we can just bypass it. I don't think that formality needs to hold us up. So I'll call it myself. This is a mention for case number 11 of 2021 against David Curley, the Queen and David Curley, and the Queen and Christopher Clark and Gareth Adderley on indictment number 11A of 2021. And I can see that I have the prosecutor, Ms. Gardner Brown, present.
Good afternoon, milady.
Yes.
Mr. Pettingill actually signed in previously on the link that we had earlier.
Yes,
So he is trying to sign in on this link. He appeared
Understandable.
for Mr. Curley.
yes. I see that we have other counsel though. I see Mr. Dismont.
Good afternoon, lady.
Yes, good afternoon to you.
And both Mr. Curley and Mr. Adderley are online. Milady, I may be assisted by counsel Mr. Dismont, but when we were on the other link, neither Mr. Clark nor his attorneys were on that link. So I'm not sure if they logged in after I left to log in here.
Right. So that would be Miss Greening and or Mr. Warner.
Yes, dear milady. And Ms. Dyer did send an email to all counsel informing us of the new link with the new information.
Right. Well, apologies for any confusion that caused. It was certainly my hope that we would only have one Zoom session for any matter coming in front of me this afternoon. It would be time consuming to do it in two separate sessions.
No need for apology. Thank you, milady.
Understandably, milady, and I see Mr. Pettingill is here.
Yes, we have Mr. Pettingill. Good afternoon to you, Mr. Pettingill.
Afternoon, ma'am. I was here on time before.
No, I understand. In fact, I was just giving out an apology to all the parties for the changes
not at all.
in details. It was only because I had another matter and it made sense to me that they all should be in the same Zoom session. As
Understood.
they're all
Thank you.
criminal open court matters. All right, so we have everyone then. This was set for a mention and also for us to come back with what has now been filed as severed indictments. Any issues arising?
Not that I'm aware of, milady, but you will see that on 11A, the
Yes.
Crown did make some amendments to the indictment, and
Yes.
we filed an application to amend.
Yes,
I am not aware of the position of counsel, Mr. Dismont and or Ms. Greening or Mr. Warner, milady, and we're still waiting on Mr. Clark, Ms. Greening and or Mr. Warner to
are
join
the
us.
amendments controversial?
In my opinion, no, milady.
Well, no, it's not for you to give the opinion. I
Well-
want to hear from someone else.
Of course, you don't think so.
Duplicity.
I apologize, lady. I thought you were addressing.
Yeah. Yes, counsel, let me hear from you. This is on the indictment as it relates to Clark and Adderley. So I'll ask you, Miss, well, we still don't have Mr. Warner or Miss Greening, do we?
I don't see that, ma'am.
Has anyone had any sort of correspondence with them?
They weren't on the earlier call, to my mind, either, my lady.
They
They
were,
were or not?
they were not. I did speak with both of them last week, but I didn't think of mentioning the date for today. I'd anticipated they would be here.
Right.
I'll fire off a WhatsApp right now, ma'am, while we're on the call.
Thank you. I'd appreciate that very much, Mr. Pettingill. In the interim, can I just hear from you, Mr. Dismont, in terms of the proposed amendments? Are they controversial? Do they?
Well, I think
address any issue?
I think that unnecessary, my lady. the adding the section 27 at the beginning.
I don't want to hear submissions on it. I want to know whether or not.
I think it's duplicitous, my lady. So there will be an issue,
Okay, there's an issue. Thank you. So I do need to have a separate hearing that deals with that.
regrettably.
All right.
My lady, I'll
Doesn't matter, I
hold for
have
them,
this-
particularly.
Sorry.
Sorry, Millie. I was saying I've sent off a quick WhatsApp. Ms. Green, you're usually good at responding, but I'm happy to hold, particularly as a matter of severance. So it's no conflict for me to hold on anything for Clark and Natalie. Oh, Ms. Greening saying she's in court.
She's probably on the other Zoom details.
I'll ask her if she wants me to hold.
Oh, court in front, as in front of another judge?
I don't know, Mom. She just said I'm in court.
Right.
And I've just said, do you want me to hold?
Well, first off, Mr. Dismont. Sorry, I'm just trying to get my note. Oh,
She
I
says,
see.
yes, please, Mom.
Sorry?
She asked me if I would.
Okay,
And
so you're
sends her
holding.
apologies. Yes, she says their submissions will be filed on the 3rd in time for conflict hearing on the 10th. She apologizes. She believed they were going back on the 10th.
Yeah, I directed for, I think, the evidence to be filed by the 20th of October. Ms. Gardner-Brown, was any
It was
evidence?
filed, milady, on the 21st of October.
I see.
And based on the affidavit that was filed, the Crown has no further evidence or any affidavit in reply to file, milady.
Okay,
But milady, counsel is speaking about the actual submissions because in dialogue with me, she did indicate that they would be filing submissions in response and relying on cases.
okay. And the hearing, remind me, the hearing that I have listed for the 10th of November is completely on the issue of counsel having to.
Recuse himself.
Withdraw. Yes, milady, having to recuse himself.
Okay.
So milady, the
Mr.
whole case
Pettingill,
got-
you wouldn't happen to know, as you're holding for Ms. Greening, you wouldn't happen to know whether issue is also taken with the proposed amendments to the indictment 11A?
I'll ask, Mom. I don't have it right here.
Well, I suppose I'm not really sure how much further that takes me, actually, because Mr. Dismont has confirmed that he wants to object, so I obviously have to set a hearing for that.
Yes, I'll let them know. I think they're lumped in, but if I may, I think obviously the issue of Mr. Warner, whether he's conflicted or not, is kind of the leading issue,
Right.
I would think. I will ask them.
Any reason?
But as you say, Mom,
why I
one follows
can't
the
say-
other, I think.
Yes, any reason why I cannot put off the question of the amendments until I can mention that again at the close of the hearing on the 10th of November, where I may have some better idea how soon that might be heard or how soon it might need to be heard.
I don't see why there'd be any issues with that, my lady.
Okay.
No issue, milady, from the Crown's perspective.
Now, the only difficulty is that the hearing will be Clark. So Mr. Dismont, you would not be there, you would not otherwise be there on the 10th.
We may be present just to,
Just to observe? Oh, I see. Okay.
but we
So
won't be,
can I just liberally have the matter of the application for amendment to just follow? I'll just direct that it shall just follow at the close of the hearing on the, what you're calling the recusal application.
Miss Brady.
All right. So that's the date for the application to amend.
To proceed yet, my lady, or to set a date for it to proceed?
No, to set a date. I don't expect it to be argued, but I would have, I think I just have a better sense as to how soon it can be heard after that hearing.
Very well, my lady.
Sorry about that delay. Yes. So does
My
that,
lady, can I just, sorry, interject?
yes.
Apologies, it's just kind of important. Is this an open court hearing? Because I just know that it's on YouTube.
Well, this is just a mention in an open court proceeding, yes.
Right.
Um,
Okay.
which underlies.
I thought so.
Thank you. This is an open court hearing, to be clear. And I think most criminal proceedings should be treated that way as a starting point. Which leads.
Sorry.
Which leads, I mean, that's always a starting point for criminal proceedings, that they're open court.
Yeah, quite, ma'am. I wasn't making an issue. I just suddenly noticed that it was on the YouTube thing, which is maybe sit back and think, now I think about it, it would be an open court. I don't disagree.
And the reason why it would not be open court next week, Wednesday. Seems to me it should be.
On what's on the,
On the recusal.
Not unless, I mean, that would be the position for council to take if there was some particular issue that they had. I don't see why it wouldn't be on a recusal application. I think that would be an open court.
We're calling it recusal. I'm
Generally.
gonna call it a removal application.
Which, my lady, I have no issue with the use of that word, even though removal does sound a little harsh. My lady.
You say recusal, it just.
Which is more for a judge, my lady.
Yes.
Which is why I have used the word.
You're asking for the court to remove counsel as counsel of record.
Yes, my lady, or have him withdraw.
Yes,
As
or
counsel of
withdrawal,
record.
whatever it
Yes.
may be. We'll see how the case law refers to it, but I don't want to cause any confusion in terms of the record, so I'm just going to continue to describe it as a removal application until I can see that there's a better terminology I could adopt. But anyway, I will list it for open court, and if an application arises as to why it should not proceed that way, then I can hear counsel. But the starting point, I think, should always be that the criminal proceedings are in open court.
Yes, my lady.
All right. Anything else in terms of the severed indictments? So for the indictment in respect of Hurley, who is your client, Mr. Pettingill, any issue arises?
My lady, I just want to indicate that really as of today, I have taken the decision and advised my client accordingly not to proceed with the section 31 application. That's just on the basis of information coming to light and a decision that I've taken at this time. So
Can I then delist
really that
the
cuts to
hearing
the
for
chase somewhat in that regard, as that was the next element we waited for.
Okay, so can I then delist the hearing for the Tuesday the 9th?
Yes, ma'am, if you would, that would be my application. I'll write to the court accordingly, of course.
So for Curly, where's this Curly? Section 31 hearing previously. Listed, Tuesday 9th listed. Okay, thank you. Thank you for that early notice, Mr. Pettingill.
Yes, ma'am.
All right. So it seems to me that that draws an end to any thing that needs to be mentioned at this stage. We'll come back and have Clark and Adderley observing, I suppose, next week, Wednesday.
My lady, could I
My
ask
lady,
just,
I'm sorry, go ahead, Mr. Desmond.
thank you, just for housekeeping, my lady, the only copy we have of the potential new indictment is the one that's redlined to be, that they're seeking to have as the amended version. Could we have a copy of the indictment without the red line, the one that they should have provided by Friday?
I'm so sorry, my lady. I'm a little confused because I did make inquiries before we served the indictment with the red highlighted sections of the amendment as to whether or not that would have been appropriate, my lady.
Well,
And-
it is appropriate to indicate what you're proposing to amend, but in compliance, in complying with the direction of the court for you to file severed indictments, what should be before the court is just a severed indictment, which is
Okay, my
unamended.
lady.
And then what can obviously, that would stand as a separate document is the indictment that you propose to be approved by the court by way of amendment in your red line. So there's nothing wrong with your red line. I just think that what Mr. Dismont is asking for is where is the indictment pre-amendment?
Well, my lady, I was not aware, and the indictment pre-amendment, those served already as one, we will just sever it and serve by tomorrow.
Okay, thank you.
Thank you, my lady.
But my lady, I thought that what counsel was going to raise, my lady, is what counsel has raised with me in correspondence over the last couple of weeks, and counsel intimated that a certain order would be sought from the court. So I am asking if I can inquire through the court, milady, whether or not counsel intends to pursue with that course of action, so we may set a date for that hearing as well.
I have no idea what you're talking about, Ms. Gardner.
Milady, I know the court is not aware.
We're not at that juncture yet, my lady. If we come to that
Well, then
juncture.
have those discussions between you, please, and then when there's something to raise with the court. I'm not a messenger or some sort of vessel for counsel to correspond with one another. Have
Thank you.
those discussions amongst you, and then when you have an application or something to raise with court, you can raise it.
Thank you,
Milady,
my lady.
I'm so sorry. I actually thought that this was something to raise with the court because
I
it
see.
concerns disclosure.
I see.
And what counsel indicated to me in his last correspondence, where he gave me a copy of the proposed order being sought, is
Okay.
that it would be filed with the court. So that is why I'm making that inquiry,
Okay.
milady.
So as reasonable as it was for you to have raised it, I understand from Mr. Dismont that it's not necessary. You can have those discussions amongst yourselves. All right. So I'll see the, we're back next week, Wednesday
Yes, my lady. Thank
at
you.
10 o'clock. Start time is 10 o'clock, okay?
Thank you, my lady.
Thank you. You can sign off. I'm going to return to the appeal matter I had.
I'm sorry, milady, we're back next week, 2:30, milady, or we're changing it to,
No,
sorry.
next week,
Okay.
Wednesday, I delisted the 2:30 matter where it concerned Curly. And we're going to be back for the removal application next week, Wednesday at 10 a.m.
thank you, milady.
All right, thank you.
So, ma'am, sorry, just so when would Mr. Curley be up to bat again? Otherwise it's sine die.
Well, I can't adjourn it, sign it. I think I have to put it.
I
into-
know.
I
Yeah.
think we'll have to go
Arraignment.
into one of the monthly sessions, and you'll have to, usually Ms. Dyer reaches out and deals with that administratively to make sure that the matters are not just left out stranded, but
With respect to,
I
ma'am,
wonder,
that was
I
my,
don't
that was
have
my
any
point
matters
on
listed.
sine die.
sorry?
And that was with respect, that was my point on sine die. If as a, if
Well, it's not going to
he's
be adjourned,
on
Friday.
bail. and-
Then let's give it a date then.
No, I appreciate that. I appreciate that. That's what I'm saying. That was my point with respect, that I think we have to give it a date.
Yeah.
Otherwise it
Yeah.
becomes that. Yeah.
My lady, when we were before you last, if memory serves me correctly, I think it was the court's intention to put us back into the arraignment sessions continually until the matter goes to trial.
Yes, no, I'm only thinking about December and January, which both have their own special
I see.
circumstances attached. Let me just look at it briefly. Any reason why I would need to mention this before February next year?
Not that I'm aware of, milady. Since we were last here, I actually have a Supreme Court trial set to start on the 2nd of February. So unless there was a date in the last week of February, milady, March 3 still would remain for the 31 application.
Yes, we were merely holding on to the arraignment dates just so we could take advantage of any matters that fell out of the list, my lady. But well, I guess there's still the possibility if we're in on February the 1st that something may free up before March. But I
Well,
don't
no,
know
I mean, if you have a need to appear before me earlier, then I'll give you an earlier date. My question is there a need for you to have a date before February 1st? I don't want to just come back for the formality of appearing if there's no issue that's envisaged to arise between now and 1st of February. Because
No,
Sorry?
I was just saying, we were just, if there was the opportunity of having an earlier date at the moment.
You will
we're-
take it.
Sorry, my lady.
You will take an earlier date.
Yes, my lady.
All right.
Those- By
so
coming in, we're closer
That's
to the
fine.
thought about if there is an earlier date.
All right, 1st of December at 2:30 PM.
Thank you, my lady.
Yep.
I'm grateful.
Okay. So, adjourned. And that is, as it currently stands, both Curly and Clark and Avenue. Okay, I'm going to put both of those matters, since they're intended to be two different indictments. Both matters will go down to the 1st of December, 2:30 for mention. Any reason why a bill would not be extended in respect of all three?
No, milady. Milady, I would just alert the court that I may be absent on the 1st. I may have to have one of my colleagues hold for
That's
me.
fine, thank you. Thank you for the notice. All right. So unless there's anything further, I can adjourn indictments 11 and 11A of 2021, Clark, Adley, and Curley.
My lady, may I be excused.
Yes, thank you very much. And
Thank you, ma'am.
Thank
I will
you, milady.
pass on to Ms. I will pass
Ms.
the
Greening.
information on to Ms. Greening now at
thank
the
you,
end of
Mr.
this.
Pettingill.
Yeah.
Thank you.
Thank you, ma'am.
All right, sorry about that, Ms. Simons. Fox, I did think it would be shorter than it was. But hopefully we can continue. Just give
Yes,
me
my
a
lady.
moment, please, let me just correct something on my note. Yes, okay.
Yes, my lady. I was able in the break to talk to our Miss Vince, who confirmed with me that the magistrate's court created an appeal record for 18 CR 00446 for our collection on August 3rd, 2021. So it may, it may have just been a clerical error as to why you don't have your copy yet or in front of you.
What's the appeal?
There is,
Okay.
unfortunately, they haven't actually filled in the number here, so I'm not quite sure what they put it as. But-
Sorry, I'm just glancing around me to see if it might, Ms. Aswood? Do you know whether or not there is another Troy Woods matter on a separate record of appeal that should have been brought up? Are you aware of anything like that?
I can inquire.
Sorry?
I can inquire, but I'm not
Could
aware.
yeah, you could just have a look into it, please.
Okay.
And then I would ask you, Ms. Simons Fox, to just proceed on the basis of the appeal being sentenced.
I'm sorry, can you just repeat that last part?
I would just ask you to proceed on the basis of the appeal again sentence as opposed
Okay.
to the point of law dealing with the probation.
Yes, okay, I will do. Your worship, my lady, I think I left off at paragraph 3 of my submissions. So the respondent was sentenced on the 6th of October to 6 months imprisonment, suspended for 12 months with an order of restitution of $500 to be paid via the court by the 30th of November 2020. The case presented by the prosecution at trial was as follows, and my lady, these notes that I'm going to go through are recorded on pages 7 to 9 of the record.
Okay. Yes.
Yes. Okay. So on the 5th of December 2018, around 7:45 p.m., the respondent stood about 4 feet from the complainant so as not to be seen by the complainant's camera, and stated to the complainant that the complainant was the reason he could not get a job, and the complainant was the reason he was taking his life. The respondent was referring to his assertion that the complainant spoke to 5 individuals about the respondent being the motorcycle bandit, occurrences that caused the respondent $100 per individual spoken to. The complainant did not speak to those individuals and only knew about the motorcycle bandit incident from the reported in the news. The respondent then told the complainant to go to the ATM at Collectors Hill to withdraw $500. The respondent went with the complainant and they arrived.
Let me just stop you there, Ms. Simons Fox. I've read all of this, and I really question whether it's necessary for you to read it back to me. The evidence was heard openly before Mr. Woods in the magistrate's court proceedings. So it's not as if you are having to read out a summary of evidence in a courtroom. It would assist me really if you just take me straight to your arguments as to why the points why you say the sentence was manifestly inadequate.
Yes, my lady. In that case, can I take you to page 5?
Yes, thank you.
At paragraph 5?
Yes.
Okay. Our submission is that the sentence that has been imposed was manifestly inadequate, including that it should not have been suspended. If you go down to paragraph 6, it is our humble submission that the Court of Appeal has held that the term manifestly inadequate can be defined as when a sentence is obviously inadequate. My lady, I'd like to take you to the case of Plant and Robinson, which should be found on your tab 1.
Yep.
I'm going to start with page 128, and then I'm going to jump through and I'll assist as I can. This is an appeal, my lady, on the 31st of January, 1983. The respondent pled guilty to the charge of looting with intent to do grievous bodily harm, contrary to section 305 of the Criminal Code. The particulars of the offense being that on the 16th of August, 1982, he unlawfully wounded his wife, Beverly, with the intent to do her grievous bodily harm. The sentence passed by the learned magistrate was 18 months imprisonment, suspended for 2 years. This appeal by the informant, Cyril Edward Plant, brought under section 17A of the Court of Appeal Act 1964, the ground of appeal being that the sentence of 18 months imprisonment suspended for 2 years was so lenient as to amount to a sentence in law and was thereby manifestly inadequate. My lady,
Can you
if I
just tell
can,
me why you're citing this case? What's the how does this case assist?
this case assists in the definition of what is inadequate from the Court of Appeal. So we go through the obviously
Well, why don't you just
inadequate.
take me straight to that passage, or just
Yes, my lady. If I can take you then to page. I believe it's 147. It's a bit cut off, but at the top of the
have you
page.
reproduced it in your submissions?
Yes,
Okay, so can we just look at your submissions?
yes, my lady.
All right.
So obviously inadequate, It is obvious to the appellate tribunal that the sentence is much too low and fails to reflect the feeling of a civilized society to the crime in question, which we say is what's taken place here. The term is further defined as obviously insufficient because the judge had acted on a wrong principle or has clearly overlooked or undervalued or overestimated or misunderstood some salient features of the evidence. It is a failure to apply right principles. So as far as this case is concerned, my lady, the maximum penalty for obtaining property by deception is a fine of $10,000 or imprisonment of 5 years or both. It is our humble submission that the sentence imposed of 6 months imprisonment suspended for 12 months with an order for restitution of $500 fails to reflect the established principle for an offense of this nature, particularly the principle of proportionality. It does not take into account the needs of society as found under section 53 and 55 of the criminal code, which, my lady, is at your tab 2. It is also our humble submission, my
All right,
lady.
just remind me, where's the sentence that was passed in the record?
Yes, my lady. You give me 1 second. I believe it's page 14, but the sentence starts on page 13 and over to 14.
Okay, so 6 months imprisonment suspended for 12 months with an order of restitution of $500.
Yes.
So what's the first point? You said the 6 months was too high, too low?
Too low. It's
So
too
it should
low.
have been more than 6 months imprisonment.
Yes.
What's the range that you say it should have been?
We say that it should have been a period of 12 to, I believe 12 to 14 months. And that it shouldn't have been suspended.
Sentence.
12 to 18 months, my apologies, my lady.
And what do you say about the suspension?
That it should not have been suspended.
There was no proper cause for suspension, you
There's
said.
no proper cause for suspension. And that the offense, had taken place 4 weeks after the respondent started his probation on another matter. And that it is a similar offense as well.
What was the offense for which he received probation?
Yes, my lady, it's on the information. There are 9 counts, 3 of which are TWOC, and the rest of them are obtaining property by deception.
Do I have on this record his antecedent history, which would include those offenses for which he received probation?
My lady, if I can just double check. I do not see its previous convictions on this record, but I can, after this hearing.
Magistrate would have been made aware of his previous convictions,
Yes,
so it should be on the record then. It's an odd thing not to be on the record for an appeal against sentence.
it is. My apologies. I found it stuck in between 2 papers, starting at page 42.
42?
42 and going to page 52.
All right. Oh, I see it. Thank you. So where he received the probation is on page,
Should be near.
so in ascending or descending order on the date?
It will be page 52. The last page is
All right.
the probation for the previous matter. Unfortunately, it doesn't list out the counts at least as it starts.
This is, how long has this format been in for the record of convictions? Is this something that's been in for a few years?
I would say a year, maybe 2.
I suppose it takes some getting used to.
Yeah, it does.
Um,
It take me.
So the offense would have been on, is that what's on the preceding page where it says?
Yes,
9th of September 2018, obtained property by deception?
yes. It seems
And-
that they have broken down each count
I see.
into a subsection of the table.
Right,
So I would say that it starts on page
Page 51.
49.
oh, 49?
I believe so. Yes,
Oh, I see.
49.
So each, so all of these different boxes deal with the different counts on which you were
Yes.
convicted. Okay,
Yes,
so 49,
252.
at the top of 49?
No, the second box.
I see it, thank you. And the date that of conviction is there as the 7th of November 2018, or is it the other way around?
I believe the date of conviction would, well, the date on the, sorry,
Yes, it says the date of conviction, 7th of November 2018.
I have the probation order in front of me. The date of the sentence,
Sorry, Ms. Simons Fox, I'm just getting some information about the other file. What happened? Do we know where it is? Okay, if you don't find it, then we'll do it on a separate date.
Thank you.
All right, thank you.
I have the probation order in front of me, and it states that that he pled guilty on the 17th day of September 2018, and the probation order started on the 7th day of November 2018. So that must be when they passed sentence after all the reports.
Not sure I completely followed you. So the sentence date, as opposed to, there are two separate boxes here. One is for conviction date and the other is for sentence.
Yes. I see, and the sentence date is blank, but from the probation order, I would say the sentence date was the 7th day of November 2018.
I see. And when was the conviction date?
The 17th of September 2018.
Right, 17th of September. Thank you, Gina. And that would apply for all of them.
All of them, yes. So it's the 1 count of TWAC, 3 counts of obtaining property by deception, and 4 counts of attempting to obtain property by deception.
And the relevance of all of this is that this undermines the reasonableness of suspending the imprisonment sentence, because
Yes,
these sentences were set to run some 4 weeks, you said, before.
before this offense, yes.
So this offense was committed on, let's see, what's the date of this offense? The 5th of December, 2018, yes?
Yes.
And I have that file now in front of me, which has an appeal number assigned 27 of 2021.
Thank
So
you.
I suggest that we just deal with it.
Thank you, my lady.
If time permits, actually, I'm not sure that we actually will be able to get through that this afternoon. I would like us to finish within the hour. But let's see how far we get.
Yes, my lady. So we submit that those are the salient features of the evidence that presented at trial that the learned magistrate made no mention of when imposing his sentence.
Mhm.
We therefore respectfully submit that the sentence imposed by the learned magistrate was obviously insufficient because the learned magistrate overlooked these salient features of evidence when sentencing the respondent and overlooked, we say that he committed these offenses while on probation. And the number one thing on the probation order, the first item on the probation order is that he not commit any further offenses.
Right.
My lady, if I can take you to your tab 3 for the case of Garth Bell,
Yes.
which the it is a Court of Appeal case that discussed the reasons for suspending a sentence.
I was taking through this case earlier this week. If it assists you in your case in taking me through it, no.
Yes, my lady, that does assist. What I am drawing your attention to, although I will not read out it in full, is paragraphs 25 to 31.
25 to 31.
Yes.
Okay. Yes.
And I want to note that there has to be some good reason for a judge to act differently as far as suspending a case. So I just want to go through if I can start at 25, and I'm not going to take you through all of it, but I would like to start.
That's fine. Take me through whatever you need to. I said that not to rush you, but just to give you some context that I have some familiarity with the matter, but that's not to prevent you from taking me through any passage you want to highlight.
Thank you, my lady.
Mhm.
25 reads, as the court there indicated, there was a practice that followed Johnson was an appeal to the court. See 2004 Bermuda Law Reports, page 63 at paragraph 20. Justice Evans, given the judgment of the court, said, it could not be said that exceptional circumstances existed in the present case. The judge erred in this court's view in holding. My lady, I think we lost the respondent.
Looks like we did. Ms. Aswad?
Just give me a moment.
Sure.
Thank you, sir. Justice
That was
Chair,
quite
I've asked him
reasonable.
to sit behind me for now because his PC was not working because to do with network issues.
All right, well, let me make sure that he can hear us clearly because the whole point is that he's got to be able to hear us. Mr. Woods, are you struggling to hear? Because Miss, you shouldn't, I don't want the court associate to feel like you are having to be in her close company either. That's not fair to the court associate.
You can just sit up just a little bit. It'll be fine.
All right,
You can hear him.
I hear you, ma'am.
You can hear?
Yeah, I was trying to say something. Can I speak? Is it possible I can speak?
Oh, you'll be called on to speak. You'll have your opportunity to speak. Keep your mask on, sir, please, while you're around the court administrator's desk. Thank you. Yes, you will have the opportunity to speak, but it's the prosecutor's turn to just make her submissions. And then I will turn to you.
Okay, ma'am.
Yes, so you were inviting me to look at paragraph 25 of the case Garth Bell. And saying that, Mr. Woods, you have received copies of the record of appeal. You have your papers in front of you?
Yes, I do. But I have my reading glasses. I can't see it.
You can't,
I have my reading glasses,
right?
so I can't really see the words. It's blurry.
Oh, the glasses you're wearing are for a different purpose?
Yeah.
I
And
see.
I put down my probation officer and my people to help me out, too, ma'am. Because today we knew it was on November the 1st, but we didn't know it was gonna be like a sir. So no, I had nobody here to help me out.
What did you think it was gonna be like?
Ma'am, honestly, I would not. I mean, I've been in court before now, anyway, but I'm not about a trial, not about trial. So when I speak to my probation officer and everybody, they're like, "Oh, yeah," and then I called them. I can't tell nobody. Like everybody's like not getting through.
Okay,
Yeah.
I'm not asking you about your probation officer just yet. My main concern in this moment is to make sure that you can hear everything that's being said clearly and that you can
yeah.
follow it. So the prosecutor is reading from her submissions. She's also reading from a previous case from the Court of Appeal,
Yes,
which is called the Queen and Garth Bell. It's at tab 3 of her submissions. And you should have a copy of those submissions and you should be able to follow through as I'm being addressed.
okay, well, I have to listen. So I can't see it.
All right, are you happy for us to do you want to just listen as she reads it out?
Yeah, I have no choice, ma'am.
Okay, all right. Why don't you read out the passages that you want for me to look at?
Yes.
Mhm.
Okay, so at paragraph 25, I'm going to start the passage there. It says, "It cannot be said that exceptional circumstances existed in the present case. The judge erred in this court's view in holding that certain mitigating factors, which undoubtedly are present, enabled him to suspend the sentence of 3 years imprisonment, which absent those factors, he regarded as appropriate for this offense, rather having determined that the sentence of imprisonment was inevitable following the guidance given by section 53 to 55 of the 2001 Act. He should have fixed the period of imprisonment, taking all the circumstances, both of the offense and the offender, into account. Only then was it necessary to consider whether the sentence should be suspended, and it was immediately apparent that there was no special or exceptional circumstances which could justify that course." Then, my lady, I'd like to take you to the extract that's in paragraph 27.
Mhm.
And this extract
This
comes
is just
from,
from what the Chief Justice had to say in Miller and Crockwell, and then the Court of Appeal thereafter just says that the statute, the provision is to be construed on its plain wording. It says exceptional circumstances.
yes,
One or less.
yes, my lady, and we're saying there was no exceptional circumstances in the case at bar for the sentence to be suspended.
Mhm.
So if I can continue with my submissions, my lady.
Yes, please.
If I'm at paragraph 15,
Mhm.
the Crown is also submitting that the respondent has a conviction of theft of property belonging to this same complainant in 2012. We submit at sentencing that the seriousness of the offense is amplified by the fact that the respondent was subject to the probation order, which is signed and we discussed on the 7th of November, 2018. I would like to note that this is 4 weeks before the offense was committed. However, the magistrate notes that it's 8 weeks. Would you like me, just for clarity, would you like me to touch on the probation order now that you have that file, or do you want me to leave
Yes,
that for a
it
separate
would
time?
be, I would prefer if we can just get all of it done, but I can see that Mr. Woods is still with us.
Yeah, I'm right there, ma'am.
All right. So, Ms. Woods, the prosecutor is going to go on now to address me in terms of your probation order and why the prosecutor says that your probation order should have been revoked or varied in whatever way that we're about to hear about. All right? Yes, Ms. Simons Fox.
Yes. So as discussed earlier, my lady, the probation order had the counts of taking the vehicle without consent, obtaining property by deception, and attempting to obtain property by deception and theft.
Mhm.
And the obtaining property by deception and the theft offenses are offenses which the respondent has been described as the motorcycle bandit targeting senior citizens.
Yes.
We emphasize that the respondent was sentenced to a maximum of 3 years probation, and that was 4 years before he targeted yet another vulnerable complainant. My lady, the complainant in the case, the 19 CR case, has a learning disability.
Yes.
We emphasize now that the respondent took the complainant to a full trial, which he was found not to be credible and was therefore convicted of the offense. We respectfully submit that the sentencing magistrate had a wide discretion on the sentencing power to suspend a sentence, that the power should only be exercised where there's good reason to do so. And in this case, we're saying there was no good reason to do so.
Okay, but you've dealt with the suspension. I thought you were going to talk to me about the probation.
I know I was touching on the probation. It will continue. I will continue to the probation.
Yeah,
lady.
well, just tell me plainly, what do you say that the magistrate should have done with the probation order?
Well, the magistrate had two options, my lady. He could have revoked the probation order and sentenced
And imposed a term of imprisonment.
and impose a term of imprisonment, or he could have ordered some sort of sanction. I know there is a fine of up to $500. I do understand that magistrates, when somebody does enter in on a probation order, in the beginning, it may be hard for them to get everything under control. And that might be a reason why after 4 weeks, he thought it not appropriate to revoke his probation order. However, he could have still sanctioned him the $500.
Okay, what did the Crown invite the magistrate to do?
The Crown was inviting the magistrate to revoke the probation order at that time.
All right, did you give like some submissions on it, or was it just a very brief submission?
I believe it was a very brief submission from the notes.
Well, I can't find
that I
any
have.
submissions from the Crown on the file then. I would not find any submissions from the Crown.
No,
All right. And did we have a report? I see we have a social inquiry report on page 18 of the record.
yeah.
That was after sentence, or was that after the breach of probation?
If I can just turn there.
And while you're looking at that, what I'm really getting at, the underlying issue is, to my mind, is, was this matter properly before the court as a breach of probation proceeding?
I, from my notes, I don't think it was before the court as a breach of probation proceeding at the time. I believe that this came up at the end of the sentence.
Oh, so this matter was not even properly called before the magistrate?
No, not from the notes. I mean, I was not there in time, but from the notes, I don't see that it was called before the magistrate. I believe that it was drawn to the magistrate's attention.
Well, why should he do it anything? Why should he revoke an order that was just brought to his attention? It should be before him as a breach of probation, and then Mr. Woods can address him as to why it should not be revoked. You address the court as to why it should be revoked, but how can you make complaint about the magistrate not revoking the probation order if it was merely a comment made by the prosecutor at the end of a different court proceeding?
I understand, my lady. I was not there at the time that any comments were made between the magistrate and the Crown. However, I do take note to what you're saying.
I mean, I'm not sure what you would be appealing against. How could the magistrate, it seems to me, if I understand your description properly, would open himself up to appeal if he had in fact revoked the probation if the matter was not properly before him. Because surely then Mr. Woods I would expect that what would happen is, if in this case number 446, you now have the conviction arising out of case number 350. And so now when 446 is called, the prosecutor says that some 4 weeks after the probation sentence commenced, Mr. Woods committed the following offense for which he's now been convicted and sentenced. And we, the Crown, say that this is a good basis for you to revoke the probation order. And then Mr. Woods can decide whether or not he wants to also address the court as to why the magistrate should do otherwise. The magistrate then may take it upon himself to say, actually, no, let me have a report from the probation officer, or let me at least have the probation officer present before me so I can see what the probation officer has to say about it. And then he makes a decision. That's usually how a breach of probation order proceeding would unfold, isn't it?
You're correct, my lady.
So that being said, and if you're not satisfied that that happened, what are you inviting me to do with this now?
My lady, in that case, I would drop that second part of my submissions.
I mean, you can just take this before the magistrate, and actually as a formal application. And
Yes,
then if he declines it, or if you feel that he deals with it in a way which is appealable, then you bring it back up on appeal.
Yes,
But,
my lady.
That's I think is a sensible approach on your part, Ms. Simons Fox. Thank you.
I agree.
All right, so that's withdrawn. So now, so I think I understood you to have concluded on the sentence, the appeal against sentence. So I should hear from Mr. Woods unless there's anything else that you wanted to add to that.
No, my lady, unless you had any questions.
All right, no, thank you. Okay, so Mr. Woods, can you hear me clearly still?
All right. Yes, my lady.
All right. Now, I want to explain to you in simple or simpler wording so that I'm just satisfied that you understood what all that exchange was about. You understand that before me now is an appeal by the Crown, by the prosecutor, saying that you should have gotten a more serious sentence than what the magistrate gave you when he sentenced you for the offense of dishonestly obtaining money from Mr. Kieran Smith. You remember that?
Yes, my lady.
Right. And you remember that the magistrate sentenced you to, what did he give you? 6 months imprisonment, which he suspended for 12 months, and then he ordered for you to pay $500 in restitution.
Yes, ma'am.
All right. So the prosecutor is saying that that should have in fact been a sentence of imprisonment somewhere between 12 and 18 months imprisonment, and that it should not be suspended. So it should be an immediate custodial sentence. You should be in prison for a period between 12 and 18 months is what the prosecutor says, instead of what the magistrate did. All right. You have the right to respond to what the prosecutor has just said about that. And I invite you to do that. But before you start, let me just say, in terms of the probation matter, that exchange between the court and the prosecutor just now was basically that you have not had a proper breach of probation hearing before the magistrate. So there's no reason why the Supreme Court should be dealing with that on appeal. Because even though when you were being sentenced for this offense relating to the dishonest obtaining of $500 from Mr. Kieran Smith, that was not your probation hearing. That was separate. And so there's no reason for this court to get involved with your probation hearing until the magistrate has properly dealt with it. And once the magistrate has dealt with it, if the Crown wants to appeal or if you want to appeal, then it's your right to do that. But the hearing in the magistrate's court has to happen first.
Okay, so
all I want to hear from you on is your response as to why your sentence should not be increased from 6 months imprisonment suspended for 12 months plus the $500 restitution. Why it should not be increased.
ma'am, I like from day one, that case there, I am like I showed the police, the officer that done the case and the judge and everything. I haven't done anything that I have a problem with my neighbor. Yes, in the past, I'm done wrong to him and everything, but even the cop said it's no evidence, no footage of me on the ATM, on no bike going through the city. They've been to all the cameras, ma'am, and the judge has said it's no evidence, sir. But I don't understand why they give me suspended sentence. I mean, I know I done things wrong in the past, but yeah, I'm not that person anymore. I'm done a lot of crap in my life, but I'm changed. These three probation, I'm changed. This suspended sentence they gave me, I understand, but there was no evidence. I haven't done anything. And ma'am, when I'm guilty, I plead guilty. I don't be all these years just getting on. I would have been plead guilty. But the suspended sentence, I mean, like I said, even the cops said, ma'am, on trial, there's no evidence.
Okay,
And
but
I have a
let me,
problem.
sorry, hold on, Mr. Woods. You pleaded not guilty. You had a trial and the
Right.
magistrate found you guilty. So we're
Right.
past that point right now. What this is, the proceeding that you are appearing for now is the Crown saying that you should have gotten a higher sentence. I'm not
Okay.
assessing whether or not the magistrate rightly or wrongly convicted you. All I'm
Right.
looking at is the sentence that he passed against you. And I reminded you that sentence was 6 months imprisonment, suspended for 12 months.
I mean,
And the prosecutor says it should not have been suspended and it should have been more than 6 months.
Okay. My lady, I hope you can find your heart and look at my suspended sentence and find your heart, please, man, to if you want to give me, Mom, I don't want to be in prison, man. But if you want to give me more probation time or something, because I can't defend myself like I wanted to, but man, I don't want a prison time. I'm done good with my suspended sentence. I ain't got no trouble, nothing. I'm doing everything I got to do with my probation and my everything. I'm doing everything right, man. And I have people that can back me up in the government building that I work with, the class I go to, would tell you. This prison sentence, man, would just set me back, moving forward in my life today. And being honest, man, I'm done with a lot of crap. I'm really changed. Like, I'm asking, man, not to continue to work with you, ma'am. I'm in programs. If you can find it hard for me to continue working what I'm doing, ma'am, I appreciate it, please. But to be incarcerated, it's like, that should be a setback in my life, how I'm moving forward today. I'm not taking away what I'm doing wrong. I have done a lot of crap, but these 3 years are the best years of me being on probation. I asked for help, and I got the help that I need. And I'm doing what I'm gonna do. I'm being honest with you, man. I'm doing all my classes, and you know, I'm glad. Like I said, I asked for help. I'm getting the help from the magistrate. And the suspended sentence they gave me was like a blow to me because I just came out of court. I'm not gonna come out of court and commit a crime like that. Like, ma'am, can I continue with my journey? Help me getting, please, my lady, please.
All right. Thank you, Mr. Woods.
Please, the lady.
No, I am not going to give a decision just yet. Ms. Simons Fox, you wouldn't have any response arising out of that. Okay.
Baby,
I was just making sure the prosecutor didn't have a further reply, and she does not. I am going to give my decision in writing. I'm going to give my decision in writing. And what that means is that I'm not going to say anything now. You are not, I think you would have bail pending appeal. In fact, he would be just serving his sentence, which is suspended at this point, Ms. Simons Fox. All right, so I'm not going to interfere with that, but I am going to make a decision and I'm going to give it in writing, and you're going to get a message from someone at the court registry
yes,
as to
ma'am.
when you have to appear back in front of me, when you have to reappear in front of me.
Yes,
You will
ma'am.
need to give that decision, okay? You understand, Mr. Woods?
Yeah, ma'am. I'm just emotional right now. Just pressed. I understand, ma'am.
All right,
Yeah, I'm getting my lady. I'm getting my help. I don't need to go backwards. Thank you.
okay. Ms. Shantae Simons, can you just remind me, when was this sentence passed by the magistrate?
Yes, my lady, it was passed on the, I think, June 10th. Oh, actually, I just had it up here. Let me go back. This will be easier for me. 1 second, my lady. October 6th, 2020. Yes.
Of October 2020. So he would have even served by now the imprisonment, the term of imprisonment.
Yes.
And he would have, you paid the $500 in restitution?
No, my lady.
Is that just a delinquency, or was that somehow stayed? Well, it
I-
wouldn't have been stayed, but you can see that the 500 was not paid.
Yes, I asked one of our clerks to check the GEM system and nothing has been paid to date. That was Friday.
Mr. Woods, why wasn't the $500 paid?
I was getting to pay it, ma'am, and people in the court building to me, since I'm getting back to court for the case, why pay $500 if I'm getting back to court, back to trial again? So they tell me to hurl off to see what the outcome
When
is.
did the
If you
magistrate
pay
direct,
$500.
oh, that's what the court clerk or court administrator told you?
No, my probation center people,
Right, okay.
they said to me, Mom, since I'm getting back to court, hurl off to see what the outcome is gonna be before I pay the $500, because I would have paid the $500. But since I'm getting back to trial,
All right, I understand. I understand. Thank you.
why pay the $500? I'm getting back.
Okay, I understand. Thank you, Mr. Woods.
Understand, ma'am?
Yes, I do. Thank you. Ms.
That was kind
Ms.
of.
Simons, Mr. Woods, sorry, I was only asking that one question. You've answered it. Thank you. Ms. Simons Fox, did the magistrate and could the magistrate have attached a default period to the non-payment of the $500?
He did not attach a default period. I note that in the sentence, I don't see any default period in his
Can a default period be attached?
to restitution. My
Yeah.
lady, I'm not sure off the top of my head. I would have to double check.
Can you check and just send me a little supplemental note as to where the court's powers are for ordering prison in default of non-payment of restitution?
Yes, my lady. And should I send that to Ms. O'Connor, to the attention of Ms. O'Connor?
Yes, yes, please. Thank you. The question I was asking earlier, which I would like to know what your position is. Your submissions are more attached to the legal principles or to this case in particular? Because in the circumstances of this case, where Mr. Simons has effectively served a 6-month imprisonment term, albeit suspended. Well, let's see, it was suspended for 12 months, and you said he was sentenced 6th of October. So even that entire suspension period is now served. Is it really fair? If I find in favor of your submissions, is it really fair for me to impose now at this stage an imprisonment term on Mr. Woods? Would that be fair?
My lady, it's unfortunate just because of the way that COVID is going and the court's diary that this matter was heard so far down the line, but there was also no other way to hear it any sooner.
Yeah.
Whether or not it would be fair, it is hard for me to say, my lady, because if this was heard in the usual amount of time pre-COVID, then we probably wouldn't be this far down the line, but this is where we are. All I can say is unfortunate. I'm not sure if it would be fair, my lady.
Would you be opposed to the court if I were to find in favor of your submissions, but I took a view that given the circumstances and the fact that the sentence has been entirely served at this point, putting aside the $500 restitution, it would be, if I made a finding that it would be unfair for me to now impose an immediate term of imprisonment on Mr. Woods under these circumstances. Is that something the Crown would be opposed to?
No, my lady.
Okay. All right. So I think the only thing I'm now interested in is the balance of that sentence, that $500 restitution, whether or not a default period can be attached to it. And I will have to consider your submissions in their fullness, in the fullness of which it was made, in fact, for the purpose of a written decision. And my questions give no indication as to what I'm going to do, but there are obviously areas that I need to address my mind.
Yes, my lady.
So I think it would be remiss of the court not to observe that Mr. Woods has already served the entire of the custodial period of his sentence.
Yes, my lady.
All right. Okay, so unless there's anything further, I'm going to adjourn at this point, and I will reserve a ruling. It will be provided in writing. It may come to you and be delivered in the courtroom or in another Zoom session such as this, but you will get that information through the court associate.
Thank you, my lady.
All right. Mr. Woods, we have email access to you. How did we get in contact with you in the first place? Or was it by telephone?
Miss Ashford has everything, has all my details.
Okay, good. All right. Okay, so we can reach you then.
Yes, ma'am.
All right. Okay, thank you. Judgment reserved, and I adjourn this hearing.
Thank you, my lady.
Thank you.
Thank you. All right. Thank you.